Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. Good to be back with you again. Before we get started, a personal thank you to Michael Groff for filling in for me yesterday. Thought I did a great job and really appreciated his help. So thank you, Michael. Let's start today with Judge Glazer, Miami-Dade.
You genuinely a good judge. That's why every time I see you on the news, I be like, man, she's a good person.
Oh, you're so sweet. You have a nice day. Okay, next we have our regular calendar. Do you need one at a turn for Enrique Mora?
Yes, that's the only one we need. It's from Metro West.
Only one. Enrique Mora, page 21.
Good morning, Rebecca Corey, Assistant Public Defender.
Good morning.
Good morning. Hi, Mr. Mora. English or Spanish? Spanish? Spanish.
Good morning, sir. You were arrested for tampering with an electronic monitoring device in criminal mischief.
Buenos días, señor. Lo han arrestado por tratar de alterar un equipo de monitoreo electrónico.
He has 3 days, no bond.
So I will appoint the public defender's office for you.
Y por daños a la propiedad, le voy a nombrar al abogado de oficio para que los represente.
There's probable cause for the charges. The bond on count 1, tampering with the electronic monitoring device, is $2,000. Count 2, criminal mischief, is $500.
Hay motivo fundado para las acusaciones en su contra. La fianza por el cargo número 1 de alterar el monitor electrónico es de $2,000 y por daño a la propiedad, la fianza es de $500.
Have a nice day.
Buen día, señor. Es todo.
Thank you. Now I have some out of turns for private lawyers. Joel Casedo on page 17.
He does need a Spanish interpreter.
Thank you. What happened? Oh. Do you have, good morning, Mr. Casedo. Do you speak Spanish?
Preferred?
Sir, you were arrested for a case from October 2nd. The charge is felony battery.
Buenos días, señor. Lo han arrestado por un cargo del 2 de octubre, agresión física como delito mayor.
Your attorney's in court. Hi, good morning. Can you state your name, please?
Yes, Your Honor. Alyssa Espinosa on behalf of Mr. Simpson.
La licenciada Espinosa, su abogada, está en la sala de su parte.
Okay, do you have any argument you'd like to make?
Your Honor, based on the lack of criminal priors and his ties to the community, including his family, his home, his business, I would ask you to consider pretrial services. Clearly, there is a very strong self-defense argument in my position on the allegations in the case. Given the fact that his since the alleged
Do you understand? I got a 26-page calendar. That's all you have to say. Thank you.
Thank you, Judge.
Okay.
¿Es interpretado, mi honor?
Yeah.
Bien, ¿algún argumento que tenga licenciada en el caso? Sí, señoría, basado en la falta de antecedentes penales y sus enlaces con la comunidad, incluyendo su hogar, su negocio, su familia, estaríamos pidiendo que sea liberado bajo un programa sin pagar fianza. Además, tenemos razón para pensar que se puede usar la teoría de una defensa propia.
The problem he has here is that he lives next door to the victim. There's probable cause for the charge.
El problema es que vive al lado de la víctima y hay motivo fundado para la acusación.
Can we have a no harmful contact order, Your Honor?
No, I can't do that. How far away is his home from the victims? Sir, how far away is his home from you? Is it 10 feet?
Es posible que se le dé una orden de que no haya contacto violento. No puedo hacer eso, señora. ¿A qué distancia está su casa de la de esta víctima? ¿10 pies? ¿Cuánto?
How far?
Acércase al micrófono. ¿A qué distancia está la casa del vecino?
I can't hear.
30, 40 feet.
Okay. So, sir, I'm going to order that you stay at least 20 feet away from the alleged victim, Victor Felipe.
Le voy a ordenar que se mantenga al menos a 20 pies de la víctima, Víctor Felipe.
No contact with the victim, Victor Felipe, either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener ningún tipo de contacto o comunicación con la víctima Víctor Felipe, ni de manera directa, indirecta, en persona, por escrito, por teléfono, mediante terceros.
So it's basically stay at least 20 feet away from the victim's home.
Entonces, básicamente,
And stay at least 500 feet away from his place of employment, school, or any other place if you see him out in the city.
se tiene que mantener al menos a 20 pies de la víctima de su hogar, lugar de empleo, lugar de estudios o cualquier lugar en donde lo vaya a ver.
Okay, also, no contact with the victim through social media or other electronic means.
Tampoco puede tener comunicación con la víctima por las redes sociales u otros medios electrónicos.
And all right, I said stay 500 feet away from the victim from his place of employment or in the street. Do you understand? You have to stay 20 feet away from him by your home and 500 feet away from him everywhere else.
Entonces se mantiene a 500 pies de la víctima en todo momento si está en su lugar de empleo o cualquier lugar fuera. Así que a 20 pies de la víctima si está en la casa, a 500 pies si está fuera.
Okay. Yeah, no problem with pretrial. There's no priors. Pretrial services, alternate bond, I'll set it at $3,000. Have a nice day. You have a good lawyer. Listen to what she tells you.
Será liberado bajo el programa. De no ser aceptado, la fianza de alternativa es $3,000. Escuche los consejos, tiene buen abogado.
All right, next, Jesus.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. It's Friday Eve today, so happy Friday Eve. Tomorrow, please do join us, our 1-year anniversary for this channel. So would love to see you all on the live show with me tomorrow. That would be great because we're gonna celebrate a little bit, I think. Wahoo, thank you for gifting a membership. Very much appreciate that. Let's keep an eye on Judge Glazer, as her audio will undoubtedly continue to fade as the morning goes on because they have just not figured out the tech in that courtroom since their quote-unquote upgrades. But for now, let's go to Judge Stevens. Say good morning to him.
And 25 CR 349 is called, the State of Texas versus Daryl James Ardoin. That's you, present with Mr. Dusler, your attorney, and the state's attorney. Earlier, you pleaded guilty to the second-degree felony of sexual assault. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
Your Honor, there are no corrections or changes concerning the defendant's version of it. He does have a little bit of dispute with some of that,
Go ahead.
The police version, but
Yeah.
it's basically just a difference of opinion. So I'm going to say we have no objection.
All right.
I have no objection, Judge.
All right, then it is made part of the record for all purposes here. And again, the agreement, whatever sentence shall not exceed a cap of 5 years imprisonment. So it's a second-degree felony. So it can be no less than 2 nor more than 5 years. A deferred or unadjudicated probation can be allowed. Is regular probation allowed under these under this set of circumstances?
Sure, Judge. Been a while since I looked at
No.
sexual assault instead of sexual assault of a child. Let me look.
Well,
So real quick, Bo and Bailey, thank you for both gifting memberships. Both of those are going to people I believe we know. Kai was not already a member, but was active with us the other day. And we've seen Sin or Sign or however it's pronounced before too. So thank you both.
Does not apply to 22011 sexual assault.
does everybody agree with that? So it's deferred or unadjudicated probation
Judge can't give him straight probation.
or flat prison time. So that's regular probation is not allowed. You're at section what? Yeah.
42A.054
Of the Texas Code of
Code of Criminal Procedure, yes, sir. Sure. Sexual assault. 22.
Say that again, 42A.1?
054.
Oh, that's what you said. Article 42A.53, which is the judge ordered community supervision, which is regular probation, does not apply to, and we looked at section 22.011 penal code sexual assault, and that's
A8.
yeah,
What is sexual assault?
that is what was indicted in this case.
Yes, sir.
That's what is that? All right. Go ahead on behalf of defense. You may go
Well,
forward, Mr. Deuceman,
thank you.
first. And
We are actually asking for deferred adjudication probation. I have spent quite a bit of time with Darrell concerning this, and he strikes me as a very sincere man who made a very, very stupid decision right before Christmas of last year. As the report indicates, they were having a Christmas party at his apartment with his daughter, a couple of other friends, and the first thing he did that was really, really stupid was providing alcohol for them. They were close to being of legal age, but not of legal age, and never should have done it. And that's the one beginning really stupid thing that happened. After that, he acknowledges that everybody drank way too much, including himself, that there's differences of opinions to exactly what happened. But frankly, he was pretty blacked out himself and doesn't even really recall the exact sequence of events. But he knows that something happened and something happened that should never have happened. He has told me that he totally accepts responsibility for this. He realizes that that was about as stupid a thing as you could do. He's written a letter to the court acknowledging that responsibility. Looking at his history, he's never had any felony of any sort, even accusations of felony. He was on one misdemeanor probation, but that was an evading arrest. It really had nothing similar to this type of offense. He's a hardworking young man. He works a full-time job as an operator at a plant. He's got a bunch of children that he supports and pays child support on. Basically, what he's saying is this was just about as foolish a thing as anybody could do. He deeply regrets what happened. In the recommendations, he does say, I'm truly sorry for my actions. I never should put anybody in that situation. Learn my lesson. It should never happen anything like this again. Hardworking citizen who made a very poor decision. And I think that pretty well sums it up. Again, he's written a letter to the court that I've shown Mr. Laird as well. And if the court wants to address him or ask him anything else concerning it, I think I've kind of spoken to the heart of what you told me. He appears to me to be a very sincere man who is accepting responsibility for something that's horrible. And I think that he's asking the court to give him an opportunity to prove that nothing like this has ever happened. Have I pretty much covered that, Darrell? Do you want to elaborate or just wait and answer any questions that Judge has for you?
let me just ask something here, Mr. Ardwan. Did you want to say anything before the state? No. Okay. One of the things that helps us judges take care of our business is we get the pre-sentence report prepared by the probation office, and they do an outstanding job. I'm very proud to work with them. They help us greatly because there's a lot we don't know. Judges and the lady next door who handle these felony cases, there's a lot we don't know about. We weren't present. So we've got to make an important decision based upon information given to us in spite of the fact we weren't present. And we have to rely on certain methods, and we rely on getting your opportunity to be heard and listening to you. And then the probation office seeks information from law enforcement who do the investigation, and then most importantly, the complainant, the victim in the case. And then they prepare a pre-sentence report, and this one is 1, 2, 3, 4 pages, and it also has a supervision plan for the court to deal with. We have the indictment, probable cause affidavit, all these things that we look at, so that that's really some of the first impressions that the judges get, is preparing for this sentencing. Each party involved has a chance to speak. You, at your plea hearing, pleaded guilty to this offense that was indicted. Second-degree felony of sexual assault, which alleges that on or about December 22nd, 2024, in Jefferson County, Texas, you intentionally or knowingly caused the sexual organ of a 17-year-old young lady, to contact or penetrate your mouth without the consent of that young girl, 17. And that's what you swore to and pleaded guilty to. You understand? You were sworn to and you pleaded guilty. So when you go to the pre-sentence investigation, this is what you said. Even though under oath you had pleaded guilty to what the indictment elements were. You say, my daughter and her friends always come to the house. Everyone was drinking. The little accuser, you refer to as the victim in this case, my daughters went to get something to eat and she left her behind. We were intoxicated. Everyone was on the couch. She came, this is the victim, sat on the couch with me. We started fooling around with each other and I said, no, I'm not going to do that. She, the accuser, the victim, touched me. The defendant, you admitted to being under the influence of alcohol at the time of the offense and explained that you blacked out and don't remember what you did. And that's your version, which was, it's her fault. That was what she did to me. But yet under oath, in front of me, you had the audacity to plead guilty to intentionally or knowingly causing her sexual organ to contact and penetrate your mouth. Oral sex is what you did. That's what you pleaded guilty to. I don't see any of that admission in here. So are you lying to the probation office or lying to me when you pleaded guilty?
No, sir. No. That's exactly what happened. They said.
No, you have two different versions. Which one, if they can't both be right?
When she says that because you were blacked out, you can't dispute that that's actually.
Yeah, I can't, yeah.
If that's what she said happened, it had to have happened.
It's exactly what.
This is your version.
Yes, sir.
But when you looked at me in the eye and pleaded guilty, we went over all of this. You looked at me and said, I'm guilty of this. And you were under oath. You're under oath. It's a document that's swearing. You took the oath. You can't have it both ways, sir.
Judge, if I might, state of Texas is not satisfied that he's accepting responsibility for what he's done, and that offer was made upon him accepting responsibility. So we would at this time withdraw the offer and ask this be reset for trial.
Judge, I don't think that the state's offer was contingent upon anything, but I do say that he is accepting responsibility for this. He's saying that he was unconscious. He doesn't know exactly what happened, but he cannot dispute that that's what she says. He said, if that's what she says happened, that's what happened. I may not remember it because I was blacked out, but if that's what she says happened, then that's what happened. And that's the way he's related to me. I think that's
What do you have?
That's where we are. And I think the state should be bound by their offer. Because it wasn't contingent.
I think they have a fair issue that's brought up.
Yeah, well,
You can't have it both ways.
He's accepting
I'm
responsibility.
accepting the responsibility, and I guess what I told her.
You're accepting responsibility, but you have two different versions.
I say I was drunk that night. I was out of there.
Who caused that to happen?
I did.
You have, do you know voluntary intoxication is not a defense to any crime?
Yes, sir.
Okay, so that's your problem. You put yourself into. But what we have here is a 17-year-old who was sexually assaulted. Let me ask you this. How do you give that back to her?
Okay.
Her innocence.
Okay.
No. And you're responsible for that, the adult. I don't even know what the price, you can't set a price on it. But when one other thing, you know, here before this occurred in 20%. In your pre-sentence report, you had an evading arrest or detention offense charged against you. It was a misdemeanor, and boom, you ended up being convicted on that crime. You were sentenced to 1 year in the jail. Then you were placed on probation for a year. That looks like it was extended for 18 months. And is that right?
Yes, sir.
Was it? Was it
Still on
1 year jail, 1 year disposition, 10/9/23, 1 year jail / 1 year adjudicated probation and $1,000 fine, 10/1/24. And then semicolon, 18 months extension. I really don't understand what that means.
Are you still on probation,
No.
misdemeanor? You're off of.
Yeah, I'm off probation.
When?
No, I get off probation like in February. But what happened on that?
No. When did you get off of probation for that?
February.
This February?
Yes, sir.
You're getting off or you're off?
I'm off.
Okay. But you were on when this happened.
Yes, sir.
But you were on probation with this, then you committed this offense? Okay. You know, criminal actions have consequences. We made that clear. You were on probation. You were convicted. And so while convicted of this crime of evading arrest or detention, you commit sexual assault on a child, a 17-year-old. I have that right, correct? Okay. The court's going to move forward on this, but
Then Judge, can I make my argument?
yes,
Before you do that?
yes, sir, you can.
Because I want you to look closely at that letter that he wrote you.
Yes, sir.
Clearing this all up and how much remorse he had for the child and what he did to her, because that letter is all about him, all about everything is always about him. Even in the pre-sentence report, there's not one thing in there that says, oh my gosh, what did I do to that girl? I wish I could help. I wish I could take it all back. I wish I could give her
And
innocence back.
but here's 3 words. She touched me.
Yeah.
But you admitted to oral sex with her.
And he calls her the little accuser.
And
That
I don't recall
Just-
saying nothing like that. I would never say nothing like that. And I actually, on the pre-sentence, I don't know if she wrote everything down, but I did.
they do.
Yeah. But I did.
They're real good about, and they're real fair. The probation office
The
isn't
whole time I
about,
was there.
listen, when I speak, stop, okay? The probation, it's a point I want to make. The probation office has a rich history of being fair. We have a 93% success rate for our probation. You think they're working against you? No, they're trying to get you across the finish line successfully. So don't say it's their fault, sir. They do their job accurately, and they take great pride in success in probations, people making mistakes, fixing it, and moving on and being the best they can be. So,
And Mr.
don't even
Deuce-
go toward the probation office is dishonest when you got two separate sets of statements made to me under oath at the plea hearing, and then here in the pre-sentence report, your words are 180 degrees different, and it tends to blame the 17-year-old. But you do say the right things in this letter. No, I was wrong. I take accountability for my action. I was going through a rough time in my life. Welcome to the world. Boy, don't we all from time to time, but we don't go out and sexually assault 17-year-olds. I mean, there are certain things that with the difficulties we all have every day in daily life, some difficulties affect our clear thinking. But it's pretty clear. You don't have oral sex with a child. After there's drinking, and then drinking. Was this at your house?
Yes, sir.
Yeah. Well, who's responsible for applying alcohol to the children?
Right.
You were. Okay. Oh. Okay. The pre-sentence report also states the mother of the victim. My daughter was supposed to be at a sleepover. You were pouring the kids alcohol like they were grown at a bar. And this event has mentally impacted my daughter. There's something else here that's in this pre-sentence report, but it's not. You know what it says. You've read it, and it's not a good thing about your reputation. All right. Anybody else have anything to say? Mr. Ardoin, anything you would like to add?
Excellent.
I have something to say real quick. Bo, thank you for gifting 5 memberships. Very much appreciated.
No.
That's not, well, this says you admitted to intentionally or knowingly doing this,
I admitted to
committing oral sex on the child.
Under the influence, no, I made bad decisions. I made bad choices.
Well,
I regret it all.
let me just say that these sorts of crimes in this court generally result in the highest form of punishment. And you were looking at this case at no less than 2 nor more than 20 years confinement in prison. And juries regularly give the maximum when they believe the crime has been committed. And this court does as well. Here is the cap. Y'all agreed on a cap. The highest that the court can set is 5 years in prison based upon the agreement. All right. I'm going to follow this agreement and find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at this plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second-degree felony of sexual assault of this 17-year-old, and I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. You will also be required to register as a sexual offender. Those are laws the state of Texas requires. Failure to properly register can result in further prosecution for the requirement of failing to register as a sex offender. Do you understand what has happened today, sir?
Yes, sir.
I just wished you would have had self-control because you say good things, but yet your actions were different.
That's my past actions, and I guarantee you, I'm not that person anymore. I'm not.
Good. That's good. But well, there's an old saying, what's in the past is never really in the past. It's still there. It has to be accounted for. Okay. That is all. Thank you.
Okie dokie. That was a fairly serious one to start off with. Well, we didn't fully start off with it, but this early in the morning. But since we're into feisty, combative, weird kind of things already, how better to follow this up than with Judge Oakley?
I have the case numbers and all that. It's the one.
Got that. You got
Did your client can repeat it? Did your client can repeat?
Yes.
Okay, yeah, I'll grab you guys' notice in just a minute.
very well. Thank you.
Mr. Beck, counsel, where have you been? I haven't seen you in seems like decades.
5 years.
How are you?
Good. How are you?
I'm doing very well. Doing very well.
That's good. It's been a while. Well, you know, I've been locked up with COVID and all that BS. So,
It's a strange new world.
huh?
Strange new world.
Oh man, it's hard to get used to it. Although I tell you, it's nice because you don't have to go court to court. You know,
Yeah.
jump in the office and then
You can actually get
one
some business.
computer to the next computer.
It's good to see you.
Good seeing you.
Hope I see you again before 5 years go by. All right, so the two that are in default were from the same incident date, I'm assuming?
There's three actually. Here's the numbers and here's what they are. If you don't know.
I think I got
Okay, yes.
Speeding, no.
BC. Yeah,
You got the ROA on it?
I can give you.
It does look like they're all out of the same use of it.
Well, why should I set the defaults aside? He wasn't smart enough to hire you early.
Correct, John.
It's all good, but
So this would be the same on all of them.
Yeah, yeah. See the 12C, the 12B, the forensic code, they will set those aside, but I've asked if they set aside the first one, which is 25 BPO.
That's the one that's really hurting him. I'll tell you what, I'll set that one aside, but he didn't show up for a hearing. It's not like he just didn't know what he was supposed to do. We gave him a notice and he didn't show up. So you can tell him the only reason he's getting one set aside is because my experience with you and I'm giving you a bump.
Thank you, Ron.
He hired the right attorney, he just didn't hire him timely enough. All right, so why don't you go back and talk to the prosecutor about that one, and see if you can do some kind of global resolution on those two files?
Yeah.
Good morning, Mr. Jones, your appearance from Ms. Hightower.
Dr. John, P5290, good morning to you and your incredible staff, including the Broncos.
She don't even live here.
I used to.
Don't underestimate her heart.
I never do. Go ahead.
Your Honor, to tell you that, the stage with Reno was so kind enough to give my, client with no criminal history the opportunity to soften the record. The reason we're pleading no contest, as you know, is we're under heavy pressure by some mean lawyers on the East Coast for civil liability.
Yeah. All right, Ms. Hightower, did you discuss your rights with counsel?
Yes.
You understand those rights and the options presented? You understand the possible penalty for today's charge? And you understand that when you say no contest, you're literally saying, Judge, I'm not fighting the charge. You understand that? And if I could find a factual basis that supports your plea, then there'll be a sentencing. You understand that?
Yes.
And based on what I see on paper, the sentencing will be a delayed sentence. All right. In understanding all of this, are you pleading no contest freely and voluntarily?
Yeah.
All right. Counsel, I think there's enough facts in the remarks section of the appearance ticket.
I would stipulate the percent.
All right, I'll accept the plea. What should I know about the nice lady before I set the terms?
She was very nervous today, and teeth, as you can see. She, I tell her she's only 24 years old, she's retired from the auto industry, never been in trouble in her license. She's self-humiliated to no end.
All right, Smith Hightower, I've been doing this a long time. When I see some 20-year-old kid in front of me that's got a retail fraud, I don't have the same concerns I do when I see somebody your age. This was not normal behavior for you. There was something going on in your life. What was going on? Are you past it? I mean, you were stressed. You were dealing with some stressors back on August 11th, right? Have you talked about it, Mr. Jones?
We have talked about it.
Are you satisfied that she's got whatever help she needs?
Yeah, sometimes you have to, people that just accept, because you know that instead of, ignoring it.
Yeah, yeah.
We've talked before, hope it's not a strategy.
Right. But she's on it. She's got a plan. Okay, all right.
This is not what she wants to be associated with.
Yeah. Oh, I'm sure it's not.
Especially with grandchildren.
Yeah. Oh, that's a tough conversation, isn't it? Yeah. All right, anything you want me to tell, or anything you want to tell me before I sentence you? Oh, I got that. I can tell by looking at it, this ain't who she is. Yeah.
I gotta tell you, she's literally the most self-humiliating person I
Yeah. Well, give yourself some grace too. I mean, whatever was going on in August, just make sure you're dealing with it appropriately. All right. Okay. I'm a big fan of counseling. Huge fan of counseling. You know how much better the world would be if every adult had the time and money to sit down with a trained, objective listener once every 2 weeks for 50 minutes?
Try to put soccer lines and those two types of people in the world. Because people who need help, they're people who get.
Yeah, exactly. Yeah, that's really true. That's really, because we're all broken. All right. Anything else? All right. Well, here's what we're going to do. You can keep your nose clean for another 6 months, right? Okay. So I'll delay sentence for that time period. I'm going to assess court costs of $300. Can you pay it today? Go down and see my cashier. She'll smile when she takes your money, and then go away and sin no more forever. Have a nice day. Always a pleasure, Mr. Jones. Are you ready, Mr. Beck? Are you ready?
A German judge.
Oh, all right. Stay seated. She's just doing the paperwork. Love the shirt. Give me a name. Again?
Just
Oh, don't have it.
I have.
How about you?
He's a Spanish interpreter.
Yep.
Wait for the.
So we're not ready on his? All right. Does anybody have anything ready?
No attorneys.
Dion Harper the second. Mr. Harper, are you going forward today without an attorney? You made a deal with the prosecutor. Says here that you're going to plead guilty to added charge, no valid operator's license on person, and the prosecutor wants me to dismiss, drove while license suspended, and a registration or plate misdemeanor, both from January 1822. Is that your deal? Did you read your rights form?
Yes, sir.
You understood those rights?
Yes.
Understand the options given to you by those rights?
Yes.
And do you understand the possible penalty for this added charge?
Yes.
Understanding all of these things, are you pleading guilty to the added charge freely and voluntarily today? Did you drive a vehicle on that date in or near Wayne Metro Airport?
Yes.
And at that time, was your license suspended, revoked, or denied?
Years ago, might be conceived.
All right, well, here's the problem I've got. I've got to know that your license was suspended, revoked, or denied at the time. Well, let me put it this way. On January 1822, did you have a valid license to show the officer that stopped you? That'll work. All right, what's the status of your license now? You're back on the road legally. Bless you. Are you working?
Yes.
Where do you work?
I work as a home office, dealer.
Online casino dealer. That's the first for me. How do you do that?
You pull up the license studio, and you just in front of the camera.
So like you're sitting on like a Zoom meeting type deal?
Yes.
Oh, interesting. All right. Well, you're the first one of those guys I've met. How long you been doing that?
On a year now, since last September.
All right, and where you been since 2022? Just laying low?
This time, Rick,
Yeah. But you got all your license stuff straightened out.
Yeah.
All right, anything else you want me to know before I sentence you?
So I did kind of want to give some context to the situation. I was at work working at the airport.
Who are you working for?
The FSM, the fueling.
Yep.
So, before work, I was going in and it was a parking spot that I was kind of waiting for. I didn't end up getting it, so I did another one, and when I'm going into work, I see the guy that was parking the parking spot, trying to make it just to him. So, again, I go into it. So anyway, I get off of work and my tire is flat. I'm like, here for security, for help, some type of investigation.
Right.
Some type of help. And this is where I'm at. This is where calling for help has brought me.
No, driving your car when you didn't have a license is what brought you here.
I mean, at a particular, I was just trying to ask.
Had you not driven your car there, you wouldn't have the ticket. Yeah.
That's
All right. Anything else? Okay. All right, fines and costs for you, $600, and I'm ordering 4 days on the court work program. We schedule a work program as an alternative to jail. You pick which 4 days you're going to work, and then those days you have to be here at 8 o'clock in the morning. Can you pay the $600 today, or do you need to talk about options? Go downstairs, sign up for the work program, and talk about your options for payment.
All set.
All set. Is it Zadeja White? One of these attorneys ready after.
Good morning, John.
Good morning. Okay.
I thought you had higher standing.
You have to educate him about that. All right, Miss White, did you discuss your rights with Mr. Gassiati? You understand those rights and the options they give you? You understand the possible penalty for allowing an unlicensed driver to operate? There better be another file somewhere. Oh, there it is. And understanding that possible penalty and the rights you have, are you in fact pleading guilty to that added charge today? Freely and voluntarily? Yes? All right. Did you drive a vehicle in Van Buren Township on July 7, 2005, while your license was suspended, revoked, or denied? Counsel satisfied? All right, it looks like the prosecutors agreed to dismiss all 3 of the original charges. And what should I know about Miss White before I sentence her on the added charge?
Car, a coffee shop right now, and very special to officer for daily, but I'm shocked like me, these one and
All right, what's the status of your license now? Still suspended? You got it back. Good for you. Good for you. All right. Anything you want me to consider before I sentence you, Miss White? Nothing you have to tell me. I'm just giving you a chance if there's something you want to share. No magic answer.
Mr. Back.
All right, Miss White, fines and costs on your file, $500, and I'm ordering 4 days on the court work program. Work program was assessed as an alternative to jail. You pick which 4 days you work. Can you pay the $500 today, or do you need to talk about options? Go downstairs and talk about all that. Good luck.
All right, I'm going to keep an eye on Judge Oakley, of course, because you never.
Well, no, you sat down and I thought, oh no, there's going to be somebody new. And I'm like, I can't handle that.
Ellie said on behalf of the people, Your Honor, the people waiving sexual conflict is honorable. People don't believe such a conflict exists. People make this waiver in avoidance of all doubt.
Thank you. Brown.
Good morning, Your Honor. Warren Brown, Deputy Chief Public Defender. We likewise do not believe that a conflict exists. This honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Thank you. Court, for its part, also does not believe there's conflict either in Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case, people of the state of Michigan versus Ronald Fleming.
Good morning, Your Honor. Ashley Lonnie Feltus with People.
There you go.
And Stephanie Cannon on behalf of Mr. Fleming, who is appearing by Zoom.
She was here.
I was,
She was.
and I heard you.
It's going to be a good day.
And Stephanie Cannon on behalf of Mr. Fleming. Mr. Fleming, could you please state your name for the record?
Ronald Fleming.
Thank you, sir.
And I do believe that there is an order of competency, and I did email the court with one yesterday. So
Yeah.
we're just asking that this be set for a PCC.
The report I have, the last report was September 22nd. Is that the report I'm looking at?
That is the one that people also have, Your Honor. It does indicate the defendant has been restored to competency and is applying to decide to be competent to stand trial.
All
We have
right.
no further evidence would stipulate to it.
I would stipulate as well, Your Honor.
All right. Court, based upon that report, would find that at this time now the defendant is competent to stand trial, would find specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I've signed your order. I will set this for a probable cause conference. How much time did you want?
Your Honor, I will just need 2 weeks. I have a phone number for Mr. Fleming. He and I will communicate in advance.
All right. Probable cause conference, October 23rd.
Thank you so much, Your Honor.
9 a.m. Bond will continue. Thank you. Thank you, Mr. Fleming.
Welcome.
Thank you.
Court does call the case of the People versus Christopher Adkins.
Yes, Your Honor, and Assistant Public Defender Nicholas Bukovich on behalf of Mr. Atkins, who appears via Zoom. Mr. Atkins, can you please state your name for the record?
Christopher Roy.
All right. I have before me a plea form. Is that what we're doing?
That is correct, Your Honor.
Plea form indicates that the defendant would be pleading guilty to added counts 2 and 3. Is that right? Are they added? No, actually, count 2, stated count 2 and added count 3. The count 2 is breaking and entering a motor vehicle, the 93-day offense, and the use of a methamphetamine, a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is an agreement that the defendant will pay restitution of $300 without a restitution hearing. That's the court's full understanding of the agreement.
Yes, Your Honor.
That's correct.
All right. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, sir.
Christopher Roy Atkins.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. The first being breaking and entering a motor vehicle to steal property less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
Also, that you'll be pleading guilty to the charge of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration at $2,000 fine plus court costs. You understand that?
Yes.
I'm sorry. Say that again, sir. You're breaking up.
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
To the charge of breaking and entering a vehicle with the intent to steal property less than $200, how do you plead?
Plead guilty, Your Honor.
To the charge of use of methamphetamine, how do you plead?
Plead guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
I understand.
You went through and signed it and had your attorney sign an advice of rights form on your behalf, or you signed it, actually signed on your behalf. You understand that, sir? Is that correct?
That's correct, Your Honor.
You have any questions regarding any of those rights?
No, I have no questions.
You understand that you're giving up all of those rights, including the rights contained in paragraph 5, those being your trial rights.
I understand.
You understand you're giving up your right to appeal of right.
I understand.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Did anybody threaten you or coerce you?
No.
All right, you're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty?
Yes, I do believe I am guilty, Your Honor.
April 28, 2024, at the location of Pickerel Lake in Dexter Township, Washtenaw County, state of Michigan. What did you do that makes you think that you're guilty of stealing property in a motor vehicle?
It was not my truck. I had no business doing what I was doing. And yeah, I was guilty.
Okay, did you come across a Chevy Silverado?
Yes, Your Honor.
Did you enter that Chevy Silverado?
Yes.
Did you take property from that vehicle?
Yeah.
I'm sorry? You did take property from that vehicle?
I did. I actually was wearing a pair of shorts from that vehicle.
Are you hearing him?
It's a little muffled. I do.
You're really muffled, sir.
You
might have to be closer to the mic, Mr. Atkins.
Okay, since he's muffled, I'm going to take just a moment. Michael Groff, 12 away from 4,000 subscribers. They just hit 3K over there on Tuesday. If you're not already subscribed to Michael, go over there now and subscribe and then come back. Please, let's get him over 4K within the next, 15 minutes. Do that for me, please. Thank you.
Mr. Atkins, had you used the methamphetamine?
Yes, I used the methamphetamine.
All right, and you knew what you were using was methamphetamine?
Yes, I was aware that I was using methamphetamine. I'm sorry.
All right. Mr. Atkins, I do have to advise you that if I accept your plea, between the time of this plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to, or the court would no longer be bound by any sentence recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
I do understand that, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, the defense is also satisfied, Your Honor.
Court will accept the defendant's plea of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
November 3rd at 9 a.m.
November 3rd, 2025, 9 a.m. before Judge Freshour. Bond in this case will continue. Thank you. Thank you, Mr. Atkins.
Thank you, Your Honor.
Court does call the case. People versus Devin Lyons Nash.
Yes, Your Honor.
Prosecution for the people.
Daddy. You might be able to handle it. He's asking for an adjournment.
Sprinting here.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender, on behalf of the defendant.
Good to see you walking in, sir. And I
Thank
mean
you.
that from the bottom of my heart.
Thank you. It's good to walk, Your Honor. Thank you.
Yes, yes, sir. All right.
Your Honor, this is a matter I have not had a chance to set up a meeting with MDOC. I'd ask the court for a brief adjournment so I can do that.
All right. And did he state his name? Mr. Can you state your name, sir?
Devin Jeremy Lyons Nash.
All right. And so you need an adjournment to set the meeting up with him?
Yes, Your Honor.
All right. Probable cause conference will be adjourned to October 30th, 2025, 9 a.m. Bond continue.
I'll set up a meeting. Okay, sir?
Yes, sir.
All right.
All right. Thank you, sir. Court does call the case of the people versus Aaron McCollum.
Stephanie Hannah on behalf of Mr. Andrew McCullum. And Your Honor, the last time I spoke with my client, he was at the Carroll facility. I spoke with him. He indicated he believes that he has been found competent. However, I don't have a report indicating that. So, Your Honor, I'm going to ask for this to be adjourned. The last report I have indicates that he is not competent and they are working to restore him. And I believe that report was from September.
Is he here? I need him to state his name. Mr. McCollum, can you state your name, please?
Andrew McCullum.
Thank you. All right, this is separate copy.
Yes.
So I'll adjourn this competency hearing. I'll adjourn it to November 13th.
Hi,
If we get a report, yes, hello.
Hi, sorry to interrupt. I work here in the court office at Carroll Psychiatric Hospital. We sent a competency report in September, and the recommendation of it was that he was incompetent and not restorable because his order expired October 4th. So he is actually already he's here on a probate order since his IST order expired October 4th, technically.
Got it. So he's there on a order from probate court?
Yeah, we got him switched over with probate court since the IST order expired.
Are you folks aware of that?
I was not, Your Honor.
I was not, Your Honor.
However, Your Honor, if the time for restoration has expired, I'd ask this case be dismissed.
I'd ask that we adjourn the matter so that we can find that actual order. And
all right. Here's what I'm going to do then. Instead of adjourning it to the November date, I think the case, if what's indicated is correct, could be resolved. I'll set it for October 30th with the understanding that there's going to be some type of resolution as to this matter, either on that date or prior to that date. October 30th, 2005, 9 a.m. Bond will continue. Thank you, ma'am, for that information. Somebody will get it straight sooner or later. All right.
Thank you so much. Is there somewhere we should be sending the report, because I believe it was sent directly to the court and we received a response from someone. So does anyone need it that did not get it?
Yes. Was that was it sent on September 15th?
I believe that was that sounds right. I don't know off the top of my head, but that sounds correct. But if you look at the recommendations at the end of it, it is that he would.
I actually do see something now in our file that was loose. Here's what I'll do. I'll still put it out to that date. I will, since you sent it to the court, but somehow or another it didn't get distributed, I'll make sure today that it gets counsel so you don't have to do anything else. I'll keep that date and hopefully we can then get it resolved either before that date via order.
Yes, Your Honor, the prosecutor and I, we work well together.
Well, that's beautiful.
So
is there any reason you need to tell me that right now?
If the timeline has ran, we just agree off the record, Nellie Prospect, get it done prior to court?
I think that's what I'm saying. But if you want to continue to talk, you can go ahead.
I miss you.
I'm not listening. All right. Ma'am, I will get this to the parties. They'll figure it out, and hopefully we won't need the 30th, but I'll put that as a control date.
Thank you.
She's gone?
I'm here. Thank you.
All right. Thank you.
And thank you, Your Honor.
She did not mean that. She's had 2 cases and already last nerve bouncing on. Court does. That's, yeah. They have it. Who has it? Oh, you sent it to them. Yes, got it. Okay. Court calls case People versus Carista Riopel.
F
And good morning, Your Honor. Assistant Public Defender Chinazi Kiriakin-Rui on behalf of Ms. Carissa Ryoka.
Oh. You didn't get the early saunter. All right, yes. Can you state your name, please, ma'am?
Carissa Ryapel.
All right. I have before me a plea form that indicates that she is going to plead guilty to 2 misdemeanor charges, counts 3 and 4. Count 3 being the use of methamphetamine, the 1-year offense, and also use of, that's Suboxone. Is that what she's?
Yes, Your Honor.
All right, use of Suboxone, also the 1-year offense. Upon her successful plea to those charges, counts 1 and 2 would be dismissed. They're agreeing also to a sentence of an immediate sentence. Court deems that appropriate. I'll do that of 321 days of jail, credit 321. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor.
Okay, I didn't know if you were bowing before me or not. Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, or nothing, and nothing but the truth, so help you God?
Yes.
State your name again for the record, please.
Carissa Ryapel.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to 2, I don't have it checked on here, but I'm presuming these are guilty pleas.
Yes, it is.
Guilty pleas to 2 misdemeanor charges. The first being count 3 of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court cost. And the other is count 4 of use of Suboxone. That's also a misdemeanor punishable by up to 1 year, $2,000 fine plus court cost. Is that correct, ma'am?
Yes.
All right. And so to those charges, to the charge of use of methamphetamine, how do you plead?
Guilty.
To the charge of use of Suboxone, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Did you go through an advice of rights with her? I don't have one.
Yes, Your Honor. She signed one. I'm waiting for them to send it back to us.
She signed an advice of rights form?
Yes, she has.
All right, ma'am, you signed an advice of rights form?
Yes.
Do you have any question regarding any of those rights?
No, I don't.
You understand you're giving up all those rights, particularly the rights contained under paragraph 5 that are on that advice of rights form?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of these offenses?
Yes.
December 2nd, 2023, at the location of the Huron Valley Correctional Facility in Pittsfield Township, Washington County, State of Michigan, did you have methamphetamine in your possession as well as Suboxone?
Yes.
Did you have any type of authority to use the Suboxone?
No.
Had you used both of those narcotics?
Yes.
All right. And you knew what you were using were those 2 narcotics?
Yes.
All right. Ma'am, if I do accept your plea, you understand that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would not be bound by any sentence recommendation or agreement, and you could not withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
I am not.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Ma'am, is there anything you want to say before the court imposes a sentence? the sentence of the court, and I will do immediate sentencing. It's my case. I'm going to sentence you to 321 days incarceration, credit 321 days served. And I will assess state minimum fines and costs of $125. All right. Thank you.
Thank you so much, Your Honor. And Your Honor, I did just forward the signed advice of rights as well as the plea form with her signature to the court's attention.
Oh, great timing. Now that we're done. All right. Court calls the case, People versus Sean.
So in a minute, we're going to go to Judge Boyd. But before we do that, are you sick of your phone ringing and ringing and ringing, and it's spam call after spam call after spam call? Well, I know I am. Or at least I was. I'm not anymore, and that is thanks to the sponsor, one of the sponsors of this channel, and that is Aura. Look, Aura is a one-stop shop when it comes to protecting yourself online and protecting your privacy and protecting your data and all of that. And one of the biggest things they have done for me is they have silenced the spam calls. If I get one a day now, that is out of the ordinary. So basically what Aura does is they go to all of the different data brokers that are online. They figure out if they have your information, and if they do, they demand that it be removed. And they have to remove it by law. And then if it pops back up, Aura will tell them again to do it, and they'll play the whack-a-mole game for you. And currently, I am now over 60 different data brokers where Aura has found my information and has continued to demand that it be removed. Some they've removed it and it's stayed away. Others, they've had to request multiple removals, but they do it for you. Not only that, they have transaction monitoring, antivirus, a VPN, parental controls. You name it, they pretty much handle it for you when it comes to protecting your online dating. See all the different features on the screen right now. So the good news, if you are interested in trying them out, because you're watching the show, you can try it 14 days for free. Aura.com/TCF. You can scan the QR code on the screen. You can type it in yourself. There's a link in the description. Whatever you want to do, just get there. You have absolutely nothing to lose because you get 14 days of it for free. And you'll find out within the first 24 to 48 hours exactly where all of your data is, and they will start removing it for you. And you can have not only peace of mind that you're more protected online, but also peace. Because again, this thing, which was ringing over a dozen times a day easily from people I had no idea who they were, has suddenly been silenced. And I can't tell you how valuable that is. So give them a try. Again, nothing to lose. Aura.com/TCF. Protect yourself online. I do. You should do it too. And quite frankly, you help support the channel by supporting the people that support the channel. So give them a look. We're all about 9 to 11% more Judge Boyd here. So let's go to Judge Boyd.
2025 CR 010462, State versus Cami Lynn Lumpkins. Can I have parties announced?
Megan Gowley for the state.
James Tochi for Ms. Lumpkins, Judge.
And are you Ms. Lumpkins?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Lumpkins, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Lumpkins, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No contest, Your Honor.
No, my question is, did you intend to give up those rights that I just mentioned to you? Do you understand those rights? Are you asking the court to allow you to enter into a plea bargain agreement with the state?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Lumpkins, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into this plea bargain agreement, you will be deported, denied re-entry and naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. They will take in consideration 2025 PF 25148, 2025 AL 006849. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 100 hours of community service restitution, no contact with
Ziamara.
Ziamara,
Perales.
Xiomara Perales, life skills course, parenting classes, and prohibited possession of firearms. Did you understand those were recommendations from the state?
Yes,
And the
ma'am.
court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead?
No contest.
State, any evidence? Thank you. State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Just a couple things, obviously, that the court follow the agreement. I don't believe Ms. Lumpkins has any history prior to this. She does have a minor dependent, Judge. I know that there's a fine, and I should have mentioned this earlier. She's not employed. She does care for the 3-year-old dependent. If you could perhaps help her with her fine. And she took a parenting class already while in custody. Just wanted to make you aware of that.
All right. So you have a 3-year-old dependent?
Yes, ma'am, but
And it-
I signed over my temporary rights to my mother as well.
And it's, I'm assuming Child Protective Services is involved?
They were involved, but they closed the case as soon as I signed over the rest of my mother.
All right. So I'm telling you all, what's the child's name?
Roman Lumpkins, RHOMEN LUMPKINS. And his middle name is Connor, CONNER.
So it's Roman Connor Lumpkins? All right, so it appears to the court that the only reason why Child Protective Services is not in her life is because she signed over rights to her mom.
Yes.
So I'm not gonna do this thing where you signed over your rights to your mom and then you go back and say, let me take my child back. Oh, well, I'm gonna make sure that doesn't happen with conditions. So when's the last time you had employment?
Last time I had employment was about 6 months before I got incarcerated. I was donating plasma to help keeping my benefits and as well as giving my son clothes and shoes that he needs.
All right, what benefits?
EBT and Medicaid for him.
All right, so then you didn't have employment. What was your employment?
I let them know that I was just donating plasma and I would get $60 to $75.
Okay, technically that's not employment. So when's the last time?
6 months before I got incarcerated.
Doing
So
what?
I was working at Babes Old Fashions restaurant.
Okay. I always see that restaurant. I've never gone in and tried it because usually I'm passing by.
Kids eat free.
Yes, they do.
Oh, so you've been, okay.
Yes.
Well, let me bring out my pigtails. Going to school.
I only went to 10th grade.
All right, why?
I was never really involved with school. I was always just running around doing a little with them. Instead of doing education, I was just running them off.
So what are your plans? Because you have a child.
My plan is to get a GED and show him that his mom can turn around her mistakes and better herself.
All right, so you're gonna have to reside somewhere other than your mom's.
I don't have anywhere else.
Well, here's the thing, I'm not, at this point in time, I can't trust you with your child at this point in time. I mean, it's a no-go for the court. This is what the court is gonna do. There's $1,000 fine. That will be probated. Court will sentence you to 4 years deferred adjudication. There's to be 100 hours of community service restitution. Ms. Abrams, the parenting classes at the jail is not going to count towards her parenting classes. Once parenting classes are completed, 50 hours will be deemed satisfied. The other 50 hours will be deemed satisfied if she obtains her GED. If for some reason you're unable to obtain your GED, then you're going to have to do those 50 hours. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be no unsupervised contact with minors. There's to be no residing in household with minors. There's to be no contact with Xiomara Perales. Take into consideration 2025 PF 25148, 2025 AL 006849. The following will be done in custody. There should be a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, then follow TAP recommendations and field visits 1 time per month until further notice or That can change if she's accepted in felony drug court, because they will do their own field visits. I'm sorry, what?
How many months of field visits?
Until further notice. All right, Ms. Abrams, is there anything else? Oh, thank you. There's to be proof of employment within 45 days of release. There's to be no employment as a home healthcare provider or with minors. And what I can tell you, because you don't have custody of your child is not with you, so those benefits should stop for you.
Yes, ma'am.
Did you read the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. We can go off the record. Here's the thing. That 3-year-old can't even fend for themselves. That 3-year-old is 100% dependent upon you. And what did you do? You drove in a vehicle that was stolen with this Perales person. And then not only that, you all are doing drugs in the car. There's drugs in the car. And let me just tell you, meth stinks to high heaven. We had a case in this courtroom where someone brought in meth, and it took us forever to get that sent out of the courtroom. And you driving around with a 3-year-old impacting their brain cells with meth and marijuana in the car.
In my defense, she didn't let me know that the car was stolen.
Here's the thing, there's no defense. There's no defense to driving around in a vehicle. And let's say you didn't know it was stolen. You had meth in your bag. She's driving away with drugs. You can't tell me that you don't know the people you hang around with. How long had you known her?
On and off for 8 years.
All right, so you've known her for 8 years. So number one, you know what type of person she is. You've known her for 8 years. And if you were to tell me it was a complete stranger, then I would be asking you, why are you getting in a vehicle with a complete stranger when you have a 3-year-old? If you want to put your life at risk, then go for it. But you're putting that child's life at risk by doing that. And signing over your rights to your mom, I already know that's the easy way out. And what ends up happening, people are in CPS court, and you know what they do? They sign their rights over to a relative. CPS gets out of their life, and then guess what they do? They go back to that relative, and then they have that child again. Not in this court. Good luck to you.
So the people that you hang with says a lot about who you are. That is my take on this. Sorry, lady, it's on you. And if you don't believe that the people you hang with says a lot about who you are, just look at this community. This is not the biggest community in LawTube, but I think it's one of the best because we're all quality people that have each other's backs, and we're hanging around with goodness, and it makes a difference. So, are we coming back for something? Let's see.
The hallway back here.
Right here?
Yeah, just go through that door.
Okay, new contestant. Let's just hang here for a minute and see what's going on.
Morning.
Oh, okay. You want me to do his part, Judge? I pretty much know it.
Let me see if there's another prosecutor in the courtroom.
While she figures that out real quick, Michael Groff, congratulations. You have now passed 4,000 subscribers on your channel. Thank you to anybody out there, Wahoo I know did, who went over and subscribed to Michael this morning to help him pass that mark. I don't know if I've stated this on the live show or not, but one of my side quests is to get Michael Groff more subscribers than I have, because quite frankly, he's better at this than I am, and he deserves it. Granted, his topic isn't quite as broad as mine is, but he's really good at what he does. I mean, he filled in for me yesterday like a pro because he is a pro. So congrats, Michael.
They're recommending revocation.
All right, it looks like they're going to take a minute to get their stuff together. Let's go back to Judge Stevens.
And you were there, Chris? 22-40158, and you were charged, as you know, with this third-degree felony of tampering with physical evidence. And also, we've got some prior convictions. Is he an habitual felon based upon this?
Yes, sir.
Yeah.
Yes.
Okay, so in this case, you were looking, if all of this was found true, you were looking at no less than 25 years imprisonment up to life imprisonment if sentenced to prison. You understand, sir? Yeah, he's,
You have to speak up.
Mr. Kimler's here. He's told you this. This states, I've got a notice here on 10-1. This from Johnny's Auto. I am deactivating Derek Lewis due to non-payment. He is currently 1,045 behind in payments. He also hasn't charged his monitor. It's been dead since 9/18/25. All right, well, one of the conditions of probation was that you have a GPS, right? And that has to be working for it to be effective. And that's the conditional bond that the court said. So what are we gonna do about that? He's now not, we don't have a GPS, right?
Yeah, I think it's something going on with my monitor, because I done had to, I didn't, not only have I get new chargers, but I had to change my monitor out before too. And I think that's due from taking baths. What about the money? The money? That's what I made it seem. He said that he would, if it was okay, I can.
You have to have a monitor. And it has to work, and that's your responsibility.
You don't know it if it's not working.
I know they're saying that it doesn't, and they also say that that it's deactivated because of non-payment. You have to pay it, and if you don't, then you're not following one of the conditions of bond that the court felt like it needed to set. Thus, the only option is for you to sit out in jail until this thing gets disposed of. What are you going to do about it? You gotta jump over the bar.
I talked to him. You know,
I want a GPS device on you. You got 24 hours to do it.
Judge, I do have an email that he's called, and my concern is that he waits till his back's against the wall to do something.
I give him you got 24 hours.
Hang on.
We're gonna set this for tomorrow morning. He fish or cut bait. You know what I mean? You either have it or your bond is revoked.
No.
Okay, it's that simple. Get it done. Get over the bar. Yes, sir.
So I have this. They can't. It's deactivated. So he don't have.
You can go to somebody else.
He's gonna charge you $1,000 to get that activated. No matter how rate, they probably will charge you less because you're the I just
You can go to somebody else to get it. But the GPS device has to be on you in 24 hours.
They reactivated it.
That
email.
That's what the email
The email
says.
says they reactivated it last night. That email.
How much did you make it? That's right, but on the first, she called me and I told him I wasn't gonna be able to pay it too.
Call Johnny's Auto and
That's from Johnny's Auto.
call them to verify this, okay?
Okay.
Please, just have a seat.
Can I tell you
Yeah.
Can I tell you one thing, Judge? On the first, when they had contacted me, I was like, well, I better make a payment.
Yes, sir.
Well, after rent, because I'm not working.
Did you make a deal with them recently?
Yes, on the first, and yesterday I made a payment. So yesterday when
they took your $200?
Yes, ma'am. I just have.
Okay, what's the next? What were you supposed to do next after that?
I'm on a payment plan, $200 every week, so I get caught up.
Okay, do you have is the GPS back on you, activated?
Yeah, I mean, I think so.
Okay, she's gonna verify that. Okay.
He's been to court.
Okay, all right. If it's done that way, then I'm satisfied. Elvin Bryant, Bruce.
Let's go, President.
At least they speak to Johnny's personally this morning, public. So it is reactivated as of 9 o'clock last night.
Okay, they say it's. Where do they go? Where'd right? They say that they reactivated it last night, and they got a deal working.
So does she need to be
tomorrow morning? No. No?
What's this?
What's the, but you need a next event, announcement or
So
something.
he's on trial, he's on trial.
Oh, okay, then
One of those days.
do we need to give him another docket, another setting
Yeah, we can-
notice for that, or is that good?
The settings, so they confirm.
Okay, all right, then it's as it is. Elvin Bryant.
Yes, I'm asking, some more time, a couple of weeks, maybe two, so that I can sit down with Mike Laird at his office. He's been in trial all week. This is a matter with the Veterans Court and,
2 weeks?
No, I remember this, Judge. We went and checked all the claims that he made in here before. The certificate that he provided to Your Honor does not come from the Veterans Court. He's been kicked out of our Veterans Court because of his non-compliance. He is subject to working something out here with this court. He's not going to get a dismissal of this matter. We've had emails going back and forth from Mr. Smith's office that included me and Mike, as well as the chief over the Veterans Court. In my opinion, he attempted a fraud on this court when he was here the last time.
This is what I had.
and that's from the Veterans Court. That's part of the Veterans Court. It is sent to the Veterans by the Veterans Court.
Okay.
He did that certificate, which we presented to the court.
Okay.
And I'm trying to get all this clear, but this is a misunderstanding.
What's state say about
I say no, Judge. That I handed that directly to my chief that runs the Veterans Court. What you're being represented by defense and partially defense attorney is inaccurate.
All right, we're gonna have a hearing on this next week. I'm gonna set this for a hearing on this matter of the authenticity of this. If it's not authentic, you will pay a severe price, and your attorney who's swearing that it's true, but I don't know why you'd say that if it wasn't. You know, but the state on the other side of the coin, the state vehemently says it's fraudulent. Well,
unless you have
everybody gets a chance
unless
to
you
be
have two
heard.
clients, Bruce, that are attempting this, I'm
Reset 1 week,
stand by
y'all
what
be
I
ready, have a hearing, and I'll make the ruling. Okay, thank you.
Well, we're not, hold on, Jenny. Yes, sir.
That's it.
Is there a suggestion that I'm part of some kind of fraud?
He says it's,
I believe
he
his
says
plan is,
it's
and I would
not.
suggest Mr. Smith.
We're gonna have a hearing on it, and I've already said everybody gets to be heard. Nobody's presented anything that supports their position. I mean, you got that, you're saying that's what it is. He says it's not, then everybody will get a chance to be heard. I've never seen had a dealing with you, Bruce, where you were proven to be fraudulent in any way. But also Mr. Ham has a reputation of being honest as well. So there's something amiss here that we need to resolve. And I'll do it next week, in 1 week. Be ready.
Yes, sir.
Kedron Corbin.
While we wait for the next contestant, Michael, thank you for gifting a membership. You crossed 4,000 subs and you celebrate by buying a membership for this community. So appreciate it, my friend.
Here, now this is a review. And the defendant was placed on 10 years probation, correct?
Then deferred in May 14th, 25, Your Honor. And there was 30 days up front jail time that was ordered to be done on weekends.
Okay.
And I believe twice we had a memo from the jail where he had showed up intoxicated at the jail during that the 30 days that he was doing.
You showed up intoxicated? Huh?
We had talked about this.
I've got the probation office here. It says, now I've reset this today for a review. Now, a motion to revoke probation has not been filed, but this state stated that you were intoxicated. They could smell liquor on you, and you said you weren't drunk, but you had been drinking. Then you admitted to drinking an intoxicating beverage before turning yourself into jail for the weekend. You were laughing, making a joke out of what you had done, this says. You were advised to quit playing around and take this seriously. Then you thought it would be funny to touch the staff in order to get his friends to laugh in the cell. You were placed in the cell in order to place you in a different location for staff safety. You were then warned not to return to jail under the influence again and not to touch the staff. You were then moved to maximum security for the remainder of that weekend. Now, that was a report that was sent on or about July 26th of this year. Had a hearing in September, this matter. Then it was set for a probation. And from probation, how's he doing?
Overall, he has done well. She tested positive once since our alcohol and has been placed on drop and has tested negative since being placed on drop.
Okay. What should we do?
I would recommend letting him continue drop and go with making AA meetings as well, which we have recently required as well.
Are you an alcoholic by any chance? Sir? Well, we told you don't drink and you're still doing it in spite of that.
I think so.
Well, the probation office's recommendation is going to always going to be, for the most part, followed because the court always feels like they're closer to you and they also have a vested interest in their track record that's so high for success. They want you to succeed. And so do I. If they say you need to go to AA meetings, then that sounds like a good idea for the time being. We'll modify, if you can get a modification to amend the defendant's probation terms to include that, the court would be satisfied. Anything else state wants to say?
No, Your Honor. I think
okay. You've got, we just started this probation. Let's don't foul it up early. Let's fix everything. Okay. You understand, sir? And that's your lifeline. They want you to succeed. If you fail, it's not their fault. Okay. I don't think we need a resetting. No. Okay. Good deal. Do well. Okay. Thank you. That is all. Joe.
All right, let's go back to Judge Boyd. I think they're ready to proceed with that one defendant now.
The state versus Beverly Marie Zuniga. And are you Beverly Marie Zuniga?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Beverly Marie Zuniga who was placed on community supervision in 2022 CR 2568 for the offense of assault family second offense on April 14th, 2022 for a term of 5 years? Is that you?
Yes.
All right, state.
We're going to proceed on number 38, Your Honor. In Bexar County, Texas, the defendant Beverly Marie Zuniga did then and there fail to report weekly for a period of 3 months as directed in violation of condition number 38.
How do you plead to that? True or not true?
True, Your Honor.
We'll waive the rest, Your Honor.
Any objections to the waiver?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, sentence you to 5 years in the prison and a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition 38?
Yes.
Court will find violation of condition number 38 true. Is there a proposed agreement?
There is not, Your Honor.
We're going to open.
We are recommending revocation and the defense would like to ask for something else.
All right, defense.
If the court is going to revoke, we ask the court to do less than 5 years. She's currently taking medication for a heroin problem. And apparently she's doing quite well on that. She's got a couple of children, the youngest being 17. So I asked the court for a little mercy in this matter and asked for credit for time served also.
All right, so Probation, what has she done?
Your Honor, can we have just a few moments to step back and review the court summary?
Sure.
Thank you so much, Judge.
They would just let me do their part.
Well, they take their few moments. A reminder, tomorrow is this channel's 1-year anniversary or birthday, or however you want to put it. But I really like to have everybody that I can there for tomorrow's live show. So if you have the ability and you could join us tomorrow, that would be great. We'll see how it goes, but I might have 1 or 2 fun things or surprises if I can get the stuff together for it. But more than anything, I would just like to gather as much as the TCF family together as possible and celebrate how we've all come together in the last year. So if you could join me for that, that'd be great.
Please step forward to the mic. This is
That's mine. You know how we do this, and we're gonna do this one. We already played through this one. We waive the rest. Where's the rest of the?
Judge, I'm ready.
All right. So defense, what are you requesting? Are y'all ready to proceed or no?
Oh, Your Honor, we seem to have misplaced the court summary. Thank you, Judge.
Sure. All right, so defense, it's my understanding from the state, they're recommending revocation. What are you requesting?
I'm asking you to. Pardon?
The state's recommendation is to revoke and sentence for 5 years, TDC.
All right, and so what are you requesting?
I'm requesting less time than 5 years, 2 to 5. I'm asking, and I want to point out that she's 40 years old. She's taking a drug right now, a prescription drug to help with her heroin. And she's doing very good on that. She has a couple of kids, the youngest being 17. And I asked the court for mercy.
All right, so is there anything you wish to say to the court?
If given the chance, would you go for?
Well, if she wants to say anything,
Okay.
then she'll need to be sworn in.
Okay.
Oh, yeah, I was saying.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Beverly Marie Zuniga.
All right, and probation, she has pled true to violation of condition number 38, and the
30.
court has found that true. All right, what would you like to say?
I was letting my lawyer know that I was likely to get my GED because I didn't finish high school. And also my grandmother, she like relied on me. She has a pacemaker in her heart. She's 87 years old. I don't have my parents. They passed away when I was very young. She's my only.
So let me ask you this. If your grandmother is relying on you, why would you come to me? And this is your third motion to revoke. And let me just remind you, your first motion to revoke was a violation of condition number 2.
Yes.
The court denied the motion, alternate in conditions to get you drug treatment. Then your next violation was a violation of number 4. The court alternate amended your conditions and continued you. And now you're back here for another motion to revoke. So why were you not thinking of your grandmother needing you before?
No, I have been, but I recently I had a stroke myself, and as you can see, my right hand is stayed messed up, and I have this on my eye from when I fell. This happened in October. It's been like trying to take care of myself and take care of my grandmother. It's been really hard, and then with my kids, my daughter, she has lupus, the 17-year-old. She's in college. She just finished school. She doesn't have a father. She just has me.
All right. So this is what the court is going to do. The court is finding violation of condition number 38 true. The court is going to grant the motion. There should be no contact with Paula Pena. There's an affirmative finding of family violence. The court will give you credit for any time served, in inpatient treatment, and the court will sentence you to 5 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision.
Because this is a felony conviction and an affirmative finding of felony violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you, Counselor. Who else?
All right, let's change it up a little bit. Louisiana, let's see if we can get a denied out of the way.
Good morning.
You mind? I gotta go into detail when I'm talking to them,
Talk whatever you talk about.
Good morning.
How you doing, Ms. Davenport? Would you state your name and DLC record?
Justice Chanel Davenport, DOC number 721-483.
Do you have a questionnaire in front of you?
Sir?
Do you have a questionnaire in front of you?
Yes, sir, I do.
Did you sign it?
Yes, sir, I did.
You understand it?
Yes, sir.
Okay. You want. My name is Chuck Phillips, and Mr. Freeman will be handling your case today.
Okay. All right, Mr. Davenport, I'm gonna read the violations to you. You can plead guilty, not guilty, guilty with a statement, or not guilty with a statement, okay?
Yes, sir.
All right. First off, they are alleging that you violated condition number 4. I will not engage in any criminal activity, nor will I associate with people who are known to be involved in criminal activity. I will avoid bars and casinos. I will refrain from illegal use of drugs or alcohol. You failed to refrain from criminal conduct while under supervision. You were arrested by the Covington Police Department on or about 7/6/25 for driving while intoxicated first. How do you plead to that charge?
Not guilty, sir. It got dismissed.
Okay. We got any proof that it got dismissed?
My husband called up there and said the clerk of court said they gave me credit for time served, and then
Well, it get dismissed, they're guilty.
okay.
Yeah, okay. Yeah, that's a big
I'm
difference.
sorry, because it's been a long time since I've been in, well, not a long time, but it's kind of the ropes are new again. I apologize. I don't really.
Okay. All right. Were you drunk that night?
Honestly, yes, I was. It was after I had got after 4th of July that weekend, and I did.
Okay. You were condition number 8. I will submit myself to available medical, mental health, or substance abuse exams, treatment, or both in order to do so by my parole officer. Also, I will submit to drug and alcohol screens at my own expense. You were referred to the Mandeville Behavioral Health to re-enroll in substance abuse treatment. You failed to enroll in treatment as directed. On 8/12/25, you were drug screened and tested positive for meth and amphetamine. You admitted obtaining a pill from someone believing it was gabapentin. Parolee Davenport pled not guilty to failing to enroll in treatment at Mandeville Behavioral Health. She stated treatment at Mandeville Behavioral Health was not part of her parole requirement. Parolee Davenport pled guilty to testing positive for methamphetamine and amphetamine. Davenport reported that this was her first positive drug screen. How do you plead to that charge?
A little of both. Not guilty and guilty. The reason I say that being because when I got granted for parole this time, I had my baby was 2 months old when I went to prison. So by me coming home wanting to start over and stay off of drugs, I got into this class called it was not reentry, it was like a substance abuse thing, like some kind of like 90-day class in Tulum. And anyways, and I still talk to the lady to this day. I got on a Vivitrol shot. And it wasn't for the drugs that I was on originally, but it helped me. It helped me. And I really, really regret getting off of it, but I got off of it during the fact that I was having a birthday celebration and everything kind of went left in. So.
And but why didn't you go back and re-enroll in treatment when she ordered you to? Why didn't you go back to treatment when your officer told you to?
With the Mandeville behavior, you have to go and follow up, but I had thought my case was still open by me being a patient for 3 years. I thought it was, but I had to go and reschedule and set up the whole process all over. And at the time, I was gonna have car problems, I was being homeless. And I had just got raped by my first cousin, so it was a lot going on in the time. And I had reached out to my parole officer and let her know, like, hey, this is what's going on, this is what's going on, but I mean, I know I messed up, but I know I also feel like if y'all have the kindness in your heart to, give me another chance, because I do have health issues that I'm suffering with, and I found out like 7 months ago that I do have HIV. So I'm just trying to better myself. That's why and it's no excuse, but
Okay.
I'm sorry.
All right, any of my colleagues have any questions? I have no further.
Carol, do you have any questions?
Well, you pled guilty, and then your domestic violence, that's the 4th offense for that.
Yes, ma'am.
And now you got a baby. So there's something going on there. Do you agree with that statement? And I know you wouldn't want to hurt your baby, right?
No, ma'am.
Okay. You're in a good place right now
And
to be able to get the help you need, substance abuse.
Have you ever been to long-term treatment?
And that's what you.
I was asking, because my parole officer went out of town,
Mm-hmm.
and I was asking her, and I said, hey, I think things are gonna go down spiral. Can we get back into this class that I used to take? Because I took the classes, but he didn't, they had changed it around, like he rotated, so he didn't do the classes that I took anymore. But I'm willing to take a further step into my sobriety. I have a 4-year-old, and my baby, I just miss her so much.
Did you have custody of your child before you were put in jail?
My mom had got emergency custody of her due to the fact that I had to deal with the time, and I was never, I wasn't gonna let her just be.
Okay.
You have any more questions?
We have recommendations.
Yes, I'm gonna make a recommendation.
Okay.
Yeah.
Okay. Mr. Davenport, everything you did, I'm gonna be told I only half believe you, to be honest with you. Now, first off, let me finish. I only half believe you. I think that wasn't the first time you'd used drugs, and I don't think it just happened because of your birthday. And you admitted you were drunk, but I'm gonna give you a break. I am gonna order, in lieu of revocation, that you go complete a long-term DOC substance abuse program. So you will not be released today. We are gonna transfer you to a long-term program. And I think they can also evaluate you for any mental health or any other kind of meds they think they need to put. Okay?
Thank you so much.
Gotta pay attention, because if you get put out that class or something, then we revoke. Okay?
Yes, sir.
All right, that's my vote.
Ms. Stapleton?
Yeah. Do we have she has a history of domestic abuse battery. Do we have?
They could probably give her either anger management or a default.
Okay. All right. So I'm going to add to mine exactly what he said, but I'm going to add to it that you attend, which is domestic violence program. Okay. Because you're a 4th offender there. And so you need help there also. Which is separate from even substance abuse. So I'm going to add that as a condition of mine. DOC approved, they call it DVOP program.
She's not been revoked, she's been.
No, in lieu of revocation, we're going to send her to.
And my vote also is to concur with my colleagues. So you will be getting some treatment, and hope you'll straighten yourself out.
Yeah, you're running out of time. Gotta get yourself straight for that child, okay?
I really appreciate it. I really do, because in the process of all that, I communicate with my parole officer because I feel like that's my second mom. And
Well, keep doing that.
I want to get myself together to take my daughter out of the environment I went through, because if somebody in my family touched me while my child's right there, I know this is not right. This is not the lifestyle I want for her. This is not what I want for myself.
Okay, good luck to you.
We're signing out. Thank you. We're signing out from,
So I'm not going to use a stinger on this one. I don't know if this is a denied or an approved as much as let's try to help and fix it. I don't know. I kind of agree with the one guy. A lot going on there. Not sure how much of it I believe, but hopefully whatever is going on, they can pull it all together. All right, let's go back to Judge Simpson for a little bit.
May I have this for Mr. Allen?
Do you solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the truth? You got. State your name.
Did she sign an advice of rights form? Are we missing that too? Ow. Well, she has to know her rights.
Yeah.
I'm gonna pass it.
Okay.
Sorry, Miss Miller.
We did discuss them.
We'll
Your
get you
Honor.
back out. We'll have the form. Everything will be in order and we'll be able to go ahead. No, good job, Chinaza. We've done 8 cases by the time we did nothing. Court calls the case People versus, is it Hatham Al Shalabi?
Check County, Your Honor.
I probably messed that up, but I did what I could.
Assistant Public Defender Hannah Apple standing in for Mr. Feaster today on behalf of Mr. Al Shalbi. Please state your name for the record.
Hatham Al Shalabi. I wasn't super.
Your Honor, we are going to ask for an adjournment. I did discuss this with my client. That is what Mr. Feaster's request is today. There's some additional information to discuss with him.
All right. Probable cause conference will be adjourned October 30th, 2025, 9 a.m. Bond will continue.
Thank you.
All right, thank you. Thank you. Court calls case People versus Johnny Bankhead Williams.
On behalf of the people, Your Honor. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bankhead Williams, who's approaching. We state your name for the record.
Johnny Bankhead Williams. Thank you.
Your Honor, we're asking this matter be set for preliminary exam.
Discovery is complete.
To our knowledge, yes.
People have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person will be set October 21st, 2025, 9 a.m. before
Judge Moore.
Judge Moore. Bond will continue. Thank you. Court does call the case of the People versus Kamani Barfield.
On behalf of the people, Your Honor.
Ron Brown, Deputy Chief Public Defender, have been with on behalf of Ms. Barfield, who approaches.
Your name?
For the record.
Kimani Barfield.
Thank you.
Your Honor, today is the date and time set for probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is complete.
Best of our knowledge.
People have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person will be set October 21st, 2025, 9 a.m. That's before me. Bond continued.
Thank you.
Thank you. Court calls case of the People versus Brandon Beliski. Please.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bill. Approaching now. Mr. Bilski, will you state your name for the record?
Brandon Travis Bilski.
All right. I have before we, is that what we're doing?
Yes, Judge, and he is executing his advice of rights form.
Thank you. All right, the plea form indicates that the defendant will be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon a successful plea to that count 2, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Brandon Travis Bilski.
Sir, it is this court's understanding that you can put your hand down, that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Is that correct?
Yes, it is.
It's understanding that you still wish to plead guilty
Yes, it is.
to that charge. How do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, I do.
You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No, there is not.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No,
Anybody threaten you or coerce you?
no, they have not.
You're doing this voluntarily
Yes, I am.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of March 15th, 2022, at the location of Carpenter Road near 3825 at the Myers Store, Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes, I did.
Had you used it?
Yes, I did.
Did you know what you were using was methamphetamine?
I did know what I was using.
Sir, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, the court would no longer be bound by any sentence evaluation in this case, and you would not be entitled to withdraw your plea. You understand that?
I do understand.
Counsel, has there been any other promises, threats, or other inducements which have led to this plea?
Not to my knowledge.
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, the people.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
October 22nd at 12 p.m.
October 22nd, 2025, 12 noon. That's before me. We'll continue.
So some stuff went down in Miami this morning. It just popped up in my feed. 27-year-old man shot 2 officers, one male, one female, both shot in the leg, taken to the hospital. They'll presumably survive, of course, if it's just a leg injury, unless they hit the right artery. But 27-year-old suspect Mason Triana found dead after SWAT standoff. So that's where that went this morning. Always a fun time in Miami, huh? Let's go back to Judge Boyd. Looks like she's got another contestant.
All right, so there's, yes,
Withdraw, but I'm not ready.
all right. So if y'all have a seat and confer with probation.
Okay.
Anyone else ready?
Yes, ma'am. It is, Edward Valdez, 4 down.
Edward Valdez.
He's in custody, Your Honor. Good morning. Good morning, Judge.
Good morning. All right. This is an old case. Is this a motion to revoke or is this?
No, this is just a setting, Your Honor.
It's a 9th setting. There's an application for PTD, Judge. We've resolved the case. So we're going to send that application in today. And he has an MTR in County Court 7. And I'm going to ask that he be held in 1.5 so we can resolve that also.
All right. I need a PTD date.
Just let me grab my calendar.
Do that November.
I'm sorry, when?
November 6th.
Okay.
What date, Judge?
November 6th. So you need to make sure you follow through on that and everything is completed. Do you understand? And then, does he have a warrant for this case?
I think so, Judge. No.
Okay. All
He
right.
was remanded without bond though on this case.
So does he have a warrant on this case or not? All right, you all need to check because otherwise he's not going to be released. All right, thank you. Just have a seat.
Judge, we're ready on Cornelius.
Thank you. Nicholas Cornelius.
So I'm not gonna have you by that
Here you go, Judge. Thank you. Do you have the motion to revoke?
Yes.
He does.
No, and I'm not here.
Yes.
Kind of different the next day.
All right, thank you. All right. We're gonna go on the record in 2021 CR 0835 State versus Nicholas Cornelius. Can I have parties announced?
Aaron Espinoza for the state.
David McLean for the defense.
And are you Nicholas Cornelius?
Yes.
State you're asking that the motion be withdrawn?
Yes, Judge, we're asking it to be withdrawn and then alter and amended to add MRT and ISP.
We're gonna have objection to that, Judge.
All right, and does he have a hold?
He has a federal hold, but he also is remanded without bond on the new case. I'm gonna file a motion to get a bond on that. I know I need to file that before the court can rule on it. I discussed that with him this morning, just strategically, how that was gonna affect his federal stuff. But I'll get that filed with the court and we're gonna request a bond on that case. I'm also working with the state. I'm hoping we can maybe get a disposition on that.
All right, because otherwise the new case. Oh, no, I see what the new case is. All right, and is there a reason for withdrawing the motion?
Your Honor, the state's position was that we are having issues with the new number one, and then as for the number twos, I guess I could have contemplated pleading on them, but I didn't.
Okay, all right. Then the court will sign the motion. The court will alter and amend conditions to include MRT and ISP. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Nicholas Cornelius.
All right, Mr. Cornelius, you understand that the state is requesting that this motion be withdrawn. Do you understand that?
Yes.
And we were set here today for a contested hearing.
Yes, ma'am.
Do you have any objections, counsel, to the motion being withdrawn?
No, Your Honor.
And Mr. Cornelius, they're asking that your conditions be altered and amended to include MRT and ISP. Do you understand?
Yes, ma'am.
And are you going to follow through with those conditions?
Yes, ma'am.
All right, is there anything else from either side?
That's further, Judge.
All right, we can close the record. Laws have changed, so new things need to be placed up on the record. If you'll give that to
I got it.
Ms. Abrams, please.
Thank you, Your Honor.
Thank you.
Appreciate it.
Yes,
On Edward Valdez, there is no warrant.
okay.
Have a seat.
All right, thank you.
Thank you, Judge. Maybe choose something?
Yes.
Thank you.
Anyone else ready?
Yes.
All right, who's your client, Mr. Callahan? Oh, they just gave me the file. Come on up. And are you all ready on him?
Yes.
All right, after I do this, I'll take that up.
Okay, thank you.
Additional tests, let me know, Patch is next. Court is calling 2025 CR 005795 State versus Linnell Trimble. Can I have parties announced? For the state,
Danny Callahan, defense.
and are you Mr. Trimble? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Am I pronouncing your first name correctly?
Yes, ma'am.
All right. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court's admonishments with your attorney, and did you understand it?
Yes, ma'am.
Did you understand you're charged with evading arrest, detention with the vehicle?
Yes.
That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights, and did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Trimble, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and denied reentry into the states. Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's an $800 fine and the state recommends deferred adjudication. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 100 hours of community service restitution, and the driving safety course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offer states Exhibit 1 in all attachments.
No objection.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments and review the same. After reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I ask the court to follow the plea agreement, consider his youth, and that no one got hurt in this case, Your Honor.
How old are you?
21.
Why are you doing this?
I was testing a dirt bike that I had just visited.
Well, doesn't a dirt bike imply that it's supposed to be ridden on dirt?
Yeah, the person I was selling it to said he was gonna get it registered.
So it wasn't registered?
Oh, yeah.
And then that still doesn't explain why you didn't pull over when they asked you to pull over. If you would have pulled over, guess what? This would have just been a ticket. And now you have a felony. Are you employed?
Yes, ma'am.
Doing what?
I work at Northeast Baptist Hospital.
Okay, how far did you go in school?
Graduated.
Do you have any children?
No, ma'am.
And who supports you? Are you living with someone?
Me and my girlfriend.
Does she have any children?
No.
All right, the court is going to sentence you to $800 fine. That will be probated. 3 years deferred adjudication. Proof of employment within 30 days. No employment as a home health care provider or with minors. Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. Regular random UAs. 100 hours of community service restitution. I'm going to order the driver safety course. Once that's completed, the community service hours will be deemed satisfied. Probation, is there anything else? Okay. Is there anything else you need from the court in order to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. Know better, do better.
Yes, ma'am.
Thank you, Judge.
You're welcome. Suzanne Kramer.
All right, let's move on for a few minutes. Let's try Louisiana again.
Good morning.
Good morning.
Chuck Tillis. We're at the Raymond Correctional Center. My colleagues today are to my right, Miss Stapleton, and to my left is Mr. Freeman. Would Mr. I don't want to mispronounce your name, but would you give me your name and DOC number?
Gazir Lakayo.
Like, what's your DOC?
306498.
Okay. Morning, Warden. Thank you for handling us today. Mr. Gazir, Mr. Freeman will be handling your case today. Who?
The staff. All right. Introduce yourself. Would staff at Rayburn introduce yourself?
Yes, we have Warden Rayburn, Warden Travis Bay here.
Simpson Harbor from Records, Tracy Taylor Classifications.
Don't worry about it, Warden. I'm stumbling too. All right, Mr. Gazia, Mr. Freeman will be handling your case today, and you have, he will be handling things for you, and he'll ask you some questions, and also some of the panel will be asking you some questions. Mr. Freeman.
Okay, Mr. Lakayo, first I'm gonna read some information into record. Correct me if anything is wrong. You are a second-class felony offender who has a parole eligibility date of 6/22/2026. You have an adjusted good time date of 6/26/35, and you have a full term date of 6/20/36. You are serving a 30-year sentence for aggravated criminal damage to property habitual. Does that information sound correct?
Yes.
Okay. First off, I want you to tell me, what did you do to get yourself put in there? And why do you think we should consider letting you out today?
It was aggravated criminal damage to property, which entails an intent. We had domestic issues with my ex-wife, and she had restraining orders. And going into the daiquiri company, when I saw her, I wanted to leave to not get arrested, and I accelerated quickly to try to get out. And we got in a collision. And from that board, I had charges of attempted murder charges or something, and they dropped it down to aggravated criminal damage to property. And I went to trial twice, got convicted, and now serving my time. I have a little little statement running down a little bit about me. I don't know if y'all want to hear this.
Go on and make a statement. You can read it.
I spoke to a warden yesterday and he asked a question that was kind of profound, and I realized that maybe I need to write this thing out to state who I am, to get better understanding. And first of all and foremost, I would like to thank God for my family and friends who supported me in this whole journey of mine. I also like to state that I would have never completed all these accomplished without God's divine assistance. I also take full responsibility in my action that led up to my conviction. I also would like to apologize to anyone I have affected in a negative way in the past. I know that I cannot change my past, but I can change my present. When I came into prison, I came with a 4th and 7th grade education level. When the beginning of my sentence, 10 years of going to appeals and fighting the sentence. I had to do with limited education at the time. And while working, I got my GED. I did automotive vocational course. I received both certification in 2 and 4-stroke small engine. I received the IC3 individual computer certificate course. I also completed living in balance, substance abuse. I did pre-release course with anger management included. I did a driving license course for renewal. I also got involved in a horticulture, and I'm going on a second time that course again. I also got involved in a leather shop and learned how to do leather work. I went ahead and decided to go into woodwork, so I had to change to go to woodwork and learn how to do woodwork a total of about 6 years. And I accumulated tools for both trades. And while serving time, I participated in any job work that I had to do, which was kitchen server for several years. I worked in the field when I came to Rayburn Correctional Center. Then I went to dorm warden for several years, and I became a trustee by the end of 2023 for approximately about a year. I also would like the board to be informed that I own and operate a cleaning service business. When I was out before this happened, I cleaned vehicles, home, business, heavy equipment, garbage containers, golf tournament events for approximately 7 years. I became associated with people, friends and customers that I end up being in contact, being in business. A gentleman named Lau J. Swing, he's a chiropractor, owns Oak Harbor Autoplex, which I bought and sold cars under his license. I also became friends with Chris and Angie Jean, owners of Coastal Waste Management. Became friends also with Glenn Hood, who owns and sells log cabins in Slidell. Became friends and customer of mine was Christy Gray. She was a physician in the community of Slidell. I have close friends that are not here, but they're very busy people, and I didn't want to burden them trying to rush them in to try to get them here to speak on my behalf, but they can be called, have numbers to contact. I have a friend named Keith D. Washington, who is a physician, MD, lives in Texas. He offered and told me anytime he needs anything to speak on my behalf, he would be there for me. I have another friend that I came associated with, Todd DeVitt. He owns an 18-wheel detail shop and tow company. He lives in Tennessee. Came to visit me recently and stated that if I needed a job, needed a place to stay, that I'm more than welcome to come live with him and also work with him as a lead man in this business. I have a friend named Raymond Monto. He manufactures dentures. He lives in Mandeville. I also grew up with Chuck Walker, who's a contractor. He lives in Slidell. I also became friends with Greg Cuvion, who's a construction builder, which his father owns a construction company that he works for. Also, I've become friends with Donnie Cannon, who's a gym teacher, owner of a karate school in Slidell. Jesus Abuelas, he sells and flips houses. He lives in Slidell. Tommy Tabasco, who's a construction company, which I work for, at Driver's Paradise, but he also became a customer when I came into the business. And
Okay.
Mike Hunt, owner of Floor Shop. And the last thing that I'm reading is the customer base. I had real estate agents, floors, hair salon business, mortgage companies, loan officers, bank employees, contractors, and most importantly, friends and family in the community, and much more. If I had a list, it would go on all my customers.
Thank you.
And this last thing I want to say is that if I got out, if the board will let me out, my goal and my main goal is to start a nonprofit organization which will teach spiritual teaching, education for the youth, domestic violence for men and women, and substance abuse classes and counseling with the help of Keith D. Washington, who is a psychiatrist, my friend. He said he would get involved and go back to business in the cleaning service business, name the Mobile Man or the Mobile King. And my motto is, be the best that you can be.
Thank
And
you
this
so
is
much.
what I'm in here, and this is what I do when I'm in prison to try to accomplish and be the best that I can be.
Okay, thank you for that statement. I do want to add a few things. It wasn't just a wreck. You ran your truck into your wife at a daiquiri shop, claimed your wife had put your son in a mental health institution. You violated protection order. You pulled her from the car and beat her. And so there was a lot more to it than what you're saying. And I'm going to get into that when I get to my questioning. Warden, do you have any comments?
As he said, he was a trustee here. He has been through some programming here, and he's in carpentry or building technology as we speak. As far as disciplinary, looks pretty clean. He hasn't had anything since about 10 years, 2015, and since he's had his last write-up. So I can't say anything negative about him as far as an inmate and being in here.
Or do you say he was or he is a trustee?
He's a trustee.
He is.
Hasn't been since he's been back in school.
Okay, thank you.
Okay, and now we want to hear from the people in opposition. I'm going to mention everybody that's here in opposition. Please excuse me if I mispronounce your names. We have David McNeese, a victim. Jody Moscona, a victim. Miss Stephanie Lacayo, a victim. Linda Brister, a victim, will not be speaking. Madison Braben, a victim, will not be speaking. Tony Nicosia, victim, will not be speaking. Kathleen Lawrence, victim, will not be speaking. Darnell Aguilar, victim, will not be speaking. Porter Easley, victim, will not be speaking. And Patrick Aguilar, a victim, will not be speaking. Did I miss anyone? Okay. All right. So we're going to go on and get into the opposition statements. Mr. Dave McNeese.
I think I'm gonna go first.
Okay, it doesn't matter. Y'all can pick order.
Good morning, honorable members of the board. My name is Jody Moscona. I am a local attorney here at Baton Rouge, and I'm here today on behalf of a good friend of mine, Stephanie Lacayo. I got to know Stephanie through her fiance, who I've been in for 30 years. And every other time that I've ever been before the parole pardon, both, I've always appeared trying to help somebody get released, because that was just a function of the relationship that I had with those particular people. But today is the very first time that I'm ever testifying trying to ask you to deny somebody's request. And that because I came to know Stephanie personally through Tony, and I didn't know anything about this case when I knew them for years and years. And it was only until this request came up that I found out any of this. And as I studied it, I became more and more concerned for the fear that I could perceive from Stephanie. I can tell you that for 19 years, I've been an ordained deacon in a Catholic church. In that capacity, I've interviewed a lot of people in very, very strained relationships. And I know that she is not exaggerating with fear and concern when you hear from her in just a little while. I don't know how, I'm not a criminal defense attorney in any way, so I don't know how the system works to wind up with the commutation, but when I read what the judge issued, it was the impression that there would not be a possibility to release it to 35. And I think that comfort is what Stephanie had prior to being notified that this parole was in fact set and that it was a possibility. And that gave rise to a whole another level of fear that I perceived from my friend that I knew nothing about for all these years. So she was at peace until this. And now she's living in anxiety. That's the only word I can get. You know, domestic abuse is now, and by the way, in my initial submission, I think Charles submitted the corrected copy. I had a typo. And this is what it's supposed to read. Domestic abuse is now front and center in our country, and every effort is being made to protect spouses that are subjected to it. It is not an easy matter to deal with because of the amount of fear that victims experience as a result of the threats that they suffer when those that are engaged in domestic violence threaten them. Stephanie has endured enough, and she doesn't need to endure anymore. I appear today to respectfully ask that you deny the parole and do everything in your power to protect my friend Stephanie. Thank you very much for your time.
Thank you for speaking. Okay, now we're gonna go to Mr. Dave McNeese.
Morning. My name is Dave McNeese.
Take your time.
Do you need somebody to stand with you, David?
The man back here came into my life when I was 8 years old. And ruined everything. My life, her life, like everyone involved with him. I never saw a single positive interaction as a kid that he had. Everything was negative. I've been in law enforcement for 18 years. The sheriff's office where I live. I have a lot of questions teaching cadets about why do you become a cop? Sorry, it's frustrating. Why do you get in law enforcement? And obviously the answer that's always given is because I want to change the world. And I always find that answer to be funny because it's something that everybody just wants to hear. And my answer was always, because I watched the cops come, I've called the cops to save my mom. And they didn't do anything. And finally it took him trying to kill her for something that happened, for some relief. And, Judge Crane was a very good judge and he understood that. He understood that this guy's a monster. And when we get into the idea, I understand what the belief of rehabilitation is in our criminal justice system. Going into the aspect of he hasn't victimized anybody in jail. And a major part of that is because his victim pool isn't in the jail. His victim pool was always women and children, which I've witnessed experience firsthand. And a lot of, to the point where he can't even admit that what he did still at this point. I think that speaks volumes of the character and the fact that he hasn't understood what he did to us. I really appreciate you talking. I'm very sorry I lost it. Thank you.
Thank you. Okay, we need to turn off the camera. It's already off. Okay, camera's off. All right, Miss Stephanie?
Hello, my name is Stephanie Lacayo, and I am the victim in this case. Thank you for allowing me the opportunity to speak at this hearing. I had asked Judge William J. Crane to sentence Gazier Lacayo to the maximum amount of time allowed by law, and he did. He heard the evidence, he heard the victim impact statements, and presided over that hearing. He came to the rightful conclusion to sentence Gazier Lacayo to 30 years to serve a minimum of 85% before eligible for parole. That would have put his first parole hearing in 2031. I was completely shocked to receive the call that he was getting his first parole hearing in 2025. There is something very wrong with this. I wasn't supposed to live this nightmare until 2031. I feel this is not just about the crime that Gazier Lacayo committed that night for which he was convicted, but for the 13 years of terror that led up to that horrific night. I had found myself in the same situation as all victims of domestic violence, alienated from my family and friends, living in constant fear, and no foreseeable way to escape. He had told me for 13 years that if I ever left him, he would kill me. And that is exactly what he did that night in 2006. I have a son from a previous marriage, David. He lived through the horror of seeing and hearing me abused. He left to live with his father at the age of 16 because he couldn't bear the cycle of abuse any longer. I thank God for that and for healing our relationship, which was absolutely beautiful before Gazier Lacayo entered our lives. He is a successful police officer today, and I'm so proud of him. The son I have with Gazier is Gazi. He could not escape. The first time he was hit, he was 2 years old, and it never stopped. Beatings and punishments that only increased in severity. He's 29 years old. He thinks he's in a coma or living in an alternate universe. He's in and out of mental hospitals. He's in a mental hospital right now. I don't know the whole argument of nature versus nurture, but I can tell you that his brain is not wired properly. And I believe a lot of that came from the abuse that he endured at the hands of Gazier Lacayo. He never stood a chance. I left Gazier Lacayo on March 6th of 2006. He waited 3.5 months until he had the perfect opportunity to fulfill his promise that he would kill me if I ever left him. He saw me alone late at night. I would like to see this parole board deny the release of Gazier Lacayo. I know without a doubt that when he gets out, he will come after me and try to kill me again. Every time he threatened to beat me, he did. He threatened that if I ever left him, he would kill me. He tried that night. He told me that if he ever went to jail because of me, that he would sit in that jail for however long it took, and he would stew on it, and he would hunt me down, and he would kill me, and he will. Not only do I fear for myself, but I also feel fear for my family, my children, and now my grandchildren. He's a vindictive, evil monster. I have scars that will never heal and nightmares that will never go away. If you decide to release him, I request there be no contact order or restraining order or monitoring. At least give me a chance to protect myself and my family. And thank you for your time.
Thank you, ma'am, for coming. I know it's difficult. Okay, all right, Mr. Lacayo. First off, you got to re-explain to me what happened. Don't tell me it was just simple criminal damage to property. What was going through your mind and what were your intentions?
intent was to get out of that location, to not break the restraint.
Okay, well, why would
She
you,
picked up and blocked the entranceway to get out. I saved her life by turning the wheel to the right, which would have not, if I would not have not done it, she would not be alive today. Though she believes, since this impact was a very strong impact, she might have believed that I was trying to kill her. But that was not the fact, because if that was the case, we wouldn't be sitting here. Plain and simple.
all right, okay,
Saved her. And I waited for the officers to show up without striking her, without doing anything to her.
so no beating or nothing, saying.
Charged with battery and other charges, which was dropped, apparently dropped, for whatever reason, this system decided to drop those charges, which is incomprehensible. If that was an intent to do, you would think they would do all these charges and convict me with those charges, but apparently they didn't.
Okay. I don't have any questions.
Ms. Stapleton, do you have any questions?
Yeah, I just want to point out that what you were convicted of, which was going to carry a 30-year sentence, you had a jury trial.
All the choices.
And it was unanimous. And I heard an attorney say something one time at a Supreme Court decision that before that, he made the comment about of the people, by the people, for the people. And he was applying that to a jury trial with 12 people that they considered, in your case, you a very dangerous person, and all 12 of them, for the sake of for the people, voted to put you in prison.
Actually, it was 6 jurors in my case.
And well, all 6 then. 6 jurors all agreed that you should be in prison. And you got the maximum sentence. So I understand the fear that your ex-wife has, because she left out of there with a thought of what she was told, and now that's been taken from her. So before I was on here, I was director of victim services for the sheriff's office where I was at. And so I had a lot of ladies that were domestic violence victims that came in, and I would help them because they didn't want to leave right then, how to have an escape plan. I would take them for their protective orders, and I made sure I wore my uniform, which of course I would have my gun with me, because their fear and what they had been through was real, and most of it goes unreported. It really does. And when a child calls 911 to protect their mother, that is at the end of the rope for that child, because they just do not do it unless they are scared to death. And all of these things happened with you. So I believe everything I heard here today from your family, and I think that you have glossed over your side of what you've done to her, even what you arrested for at the daiquiri shop. So I don't really have any questions other than I wanted to make that statement.
Okay, you have another question?
No.
Is the panel ready to vote?
Yes, sir.
Yes.
Since Mr. Freeman's case, he's going to vote first. And Mr. Freeman?
Okay, Mr. Lakeo, I find that you have no acceptance of the blame. I think you are totally in touch with reality. My vote is to deny.
Ms. Freeman?
Okay.
I mean, Ms. Stapleton?
I agree with Mr. Freeman, my colleague. I didn't find you truthful and a total lack of remorse. And also that you would be a danger to public safety because they're so fearful of you, and you could be sitting there thinking about what you're going to do when you get out. Nobody knows that other than you. But for them, when you were out, you were a danger to their life. So that's an understandable fear. So, lack of remorse, not truthful, and I do believe you'd be a danger to public safety.
Okay, there's a strong law enforcement opposition, the DA, Sheriff's Office, judges, and also my vote is going to be to deny also. So your request has been denied today. So this ends our
Denied. So I think the great Michael Groff says it best. Dude, when he said, quote, "I saved her life. I was so done I couldn't have been more done if I had an electrified done machine." Yeah, that's about right. I thought there might have been a chance early on, but yeah, just no taking of responsibility whatsoever. But it is what it is. Let's go back to Judge Boyd.
Is this a motion to revoke?
Motion to set bond, Your Honor, it's currently remanded.
All right, so. So he hasn't, this isn't a motion to revoke.
That's correct. No, Your Honor, it's a motion to set bond,
Okay,
on his matter.
all right. Does anybody have a motion for me to?
Yeah. It's Gustavo Jimenez.
All right, the court is calling 2024 CR 007456 State versus Gustavo Jimenez. Can I have parties announced?
In Galloway for the state.
Renee Munoz on behalf of Mr. Jimenez.
And are you Mr. Jimenez?
Yes, ma'am.
All right, defense has filed a motion to set bond. The defendant is currently remanded without bond. State, have you had a chance to review the motion?
Judge, may I see it, please?
Yes.
Here you go. Maybe you can hold on to that one. If I made 10 of this, I brought an extra copy.
Thank you.
You.
Okay, yes, I've reviewed the motion, Your Honor.
All right, and State, are you prepared to proceed?
Yes, Your Honor.
All right, can someone tell me what is the reason he's remanded without bond?
So Judge, she was remanded because he was initially deemed incompetent and then referred to the Kerrville State Hospital for inpatient treatment. He was deemed restored by Kerrville State Hospital and then brought back here, which is where the remand without bond occurred. Looks like that's it's put into the system on July 3rd, 2025.
Okay, let me. And so the remand without bond, though, was it just because he? Oh, wait a minute, I see what happened. He was incompetent. This is a violent offense. So
Alleged.
Alleged, yes,
Yeah.
alleged. I'm not taking this offense as true. So that is why, because the nature of the offense required inpatient treatment. And when they do that, they will remand. All right, now I know. I was trying to figure out whether or not you were remanded without bond because you didn't show up for court or something else. All right, is there an agreement on a bond amount?
Judge, that is my understanding of the reason why he was remanded without bond. We don't have an agreement, but I have no objection to the original bond amount being stated, which was 200,000.
Your Honor, we feel that amount is excessive. We're requesting a bond in a different amount than that, which is why we set that motion to set bond before the court, Judge.
Okay. And what bond amount are you requesting?
We're requesting 20,000, Your Honor, for a variety of reasons, namely because Mr. Jimenez was restored at Kerrville State Hospital. And if I may tender to the courts, the restoration packet.
Any objections?
No, I've had the chance to review, Your Honor.
And he was compliant with taking meds. He was compliant with staff there. In relation to his criminal history, this is the only violent charge that I can see him ever being alleged to have committed. So for those reasons, Judge, we believe that he needs mental health treatment. So he does not decompensate here in the jail. We're currently awaiting a sanity evaluation to take place, an evaluator. However, it's looking like that may take us into the new year, 2026. With my client being in custody and not having access to mental health resources, we don't want him to revert back to the state he was in potentially around this alleged offense. So that's why we're seeking to hopefully continue his care. I know that CHCS does have a FACT/ACT team for people with complex mental health needs. They offer psychiatric medication management, nursing services, primary care, peer support, as well as counseling. In looking to the restoration packets, I saw that was conducted at Kerrville, that he was engaging in counseling. He was consistent with his medication, and he was doing quite well, enough so that he was deemed restored to competency, Judge. For these reasons, we have filed the motion to set bond and requesting it to be set at 20,000. He doesn't have a lot of means, Your Honor. He's been in custody for approximately the last two and a half years since the alleged offense in 2024. His family members are all retired. His mother and father that he can live with are retired. But he does have that support system, and his brother is here as well, Mr. Victor Lopez also, that can help take him to appointments as necessary with Center for Healthcare Services. So in light of the case, the procedure of the case, how it went along procedurally, and the fact that he was deemed incompetent, restored to competency, and now is seeking to maintain those mental health services that he needs, we feel like him at the jail is not going to have adequate access to those services, and we just would not want him to be compensated in that fashion.
All right, so the original bond was at $200,000. So somebody else set that bond at $200,000.
Correct.
The court will need more. Is there any other evidence that anyone wishes to present to the court as to why that bond should remain at $200,000, or why? I understand what you presented to the court as to why it should be lowered.
Right.
Yes, Judge, I would tender State's Exhibit B1 for the purposes of this hearing.
No objection, Your Honor.
All right. Then the court will accept into evidence State's Exhibit B1 for purposes of this hearing only. All right, counsel, is there anything else? It's your motion.
Your Honor, if I may call a witness, my client's brother, Victor Lopez.
All right, Mr. Lopez. Oh, I'm so sorry. State, could I have B1 back, please? All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Be sure to keep your voice up so the court reporter can hear. If you could state your name for the record.
Victor Lopez.
All right, you may proceed.
Thank you, Your Honor. Mr. Lopez, how do you know Mr. Gustavo Jimenez?
My brother.
Okay, is he your biological brother?
Yes, sir.
Okay. And do you guys have any other family here in San Antonio?
My mom and dad.
Okay. So your mom and dad currently do reside in Bexar County, correct?
Yes, sir.
Okay. If released on bond and subject to GPS full house arrest, would Gustavo be able to live at your mom and dad's house?
Yes, sir.
Okay. If needed to be taken to medical appointments, such as mental health appointments, would either you or your mom and dad be able to provide that transportation?
Yes, sir.
Okay. Would you also provide a support system in terms of making sure he's taking his medication as prescribed?
Yes, sir.
Okay. Now, you yourself, sir, are you currently working?
I'm retired.
Okay. Retired from where?
US Army.
Okay. How long were you in the Army for?
12 years.
Thank you for your service, sir. But you're currently not working, correct?
No.
Okay, to your knowledge, are your mom and dad working at this time?
They retired also.
They're retired also, okay. Also further to your knowledge, is Gustavo working at this time?
No.
Okay, do you believe him to have any kind of significant adequate savings?
Yes.
Okay, you believe he has a lot of like money in the bank to afford to a bond? Like, do you believe he has a lot of money to afford a potential high bond?
No.
Okay, you just misunderstood the question, right?
Yes.
Okay, I apologize. I'll try to slow it down a little bit. In terms of Gustavo, has he ever been violent with you or your family members before?
No.
Okay. Do you believe he has any other violent charges other than this alleged offense?
No.
Okay. Are you requesting the court set a reasonable bond so that he can get out to get mental health services?
Yes.
Do you believe he needs these mental health services?
Yes.
And you would do your best to support him in that regard, correct?
Yes.
And how long have you and your family lived in Texas?
Over 20 years.
Okay. And specifically in San Antonio, how long?
18 years.
Okay. And that's here in Texas the last 18 years, more or less, correct?
Yes.
Okay. Do you guys have any other family anywhere located in Texas?
No.
Okay. Do you believe that Gustavo would be a flight risk or that he would take off and not return to court if released on a bond?
No.
Do you believe he would follow all bond conditions, even if that includes mental health treatment?
Yes.
No further questions, Your Honor.
All right, you may proceed.
Briefly. Mr. Lopez, so currently, do you live with your parents or no?
No.
Okay, so in your parents' household, who all lives there?
My mom and dad only.
Okay, and at the time that this alleged offense occurred in April of 2024, was your brother living with your parents at that time?
No.
No, where was he living?
On his own.
Okay, and you said that your family has lived in Texas for 20 years, is that correct?
Yes.
Okay, where did you all live before that?
For her.
Killeen, okay, and then was that due to military?
Yes.
Okay, and before that, where did your family live?
Puerto Rico.
Okay, do you all still have family members in Puerto Rico?
Yes.
Okay, so the only family that you have here in Texas is you, your brother, and your parents, is that correct? But you do have a lot of family members in Puerto Rico?
Yes, ma'am.
Okay, and regarding that, have you or your parents made any efforts to reach out to bonding companies to see exactly how much money it would take to post your brother's bond?
No.
Okay. And regarding, I know you said your brother has never been charged with a violent offense, but are you aware that he has a felony conviction for drug possession?
Yes.
Okay. And that was, do you recall what year that was from?
No.
Okay, but you are aware of that. Okay, we pass the witness, Your Honor.
Any further questions?
No, Your Honor, that's time.
All right, thank you so much for coming down. Any other witnesses?
No further witnesses from the defense, Judge.
All right, after hearing the evidence and reviewing all of the evidence was presented, the court will reinstate the previous bond that was set at $200,000. There's to be no contact with the following:
For the record, she muted right there, but we'll stick with her and see if she unmutes. She muted, I think, to protect the names. But I want to stick with this to see if we get any of the rest of the ruling, so hang tight.
Thank you. All right.
Your Honor, just for one thing, if released, would it be possible as a condition for the special needs unit coordinated with Center for
Yes.
Healthcare? Okay, great. Thank you, Your
And
Honor.
I'll add a special needs unit with Center for Healthcare Services.
Thank you, Your Honor.
All right, thank you. And counsel, he is set on February 3rd. If
Yes.
y'all want to come back sooner, just let the court know.
I'll get with the magistrate's office, Judge, and see if they're ever to expedite the evaluation, and we'll update the court. If that's okay?
Yes.
Thank you.
All right, thank you.
Judge, these were on Mr. Tochi.
All right, so sadly, we missed that final ruling because she muted. I get why she did though, especially as she's trying to protect names, but we don't exactly know what happened. Oh well, these are things that we don't control on a live show. It kind of is what it is. I hope you all had fun today. It looked like you did in the chat, as Ashley put it, a very feisty chat, and it was, and that's always good. And we saw some good cases, I thought, today. So we'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar. The next thing I'm going to do as soon as I'm done here is go get that episode posted. But we're going to discuss the idea of people charged with murder and whether or not they should get bail. Is that a good thing? Is that a bad thing? Is it a constitutionally protected thing? There's a whole bunch of directions we can go with that. So we'll give that a go. And we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, for the 1-year anniversary of this channel. So do please join me. Again, I just love to have as much of the community as possible there to just kind of enjoy each other's company tomorrow. And we'll be there 45 minutes early for channel members. So 9:15 Eastern, 6:15 Pacific. That sounds right. But go have yourselves a great Thursday. Can't wait to see y'all tomorrow. Thanks so much for everything y'all do for me and all the support you give me. And again, congratulations to Michael Groff on crossing the 4,000 subscriber mark during the show today. So thanks you to everybody for supporting him as well. See you all tomorrow. Take care. God bless.